Hey there and welcome to Concierge Medicine Radio, your source for actionable advice and real stories of physicians running and growing concierge practices. For more interviews and notes on today's show, please visit conciergemedicineradio.com and enter your email. Now, let's join your host, Taylor Pearson.
Welcome back to another episode of Concierge Medicine Radio. I'm really excited to bring you today's show. I just got off the call with Jim Eischen. He is a lawyer in San Diego. He specializes in setting up private and concierge practices, so he's got a lot of legal expertise in this specific domain. I do want to say that obviously I am not an expert in legal matters, and to make sure you get legal counsel before acting on anything you hear in this interview. But we go over some really, I think, important topics to touch on, and something I think a lot of people even already practicing aren't aware of. How some people might unknowingly be collecting a fee for a service provided by Medicare, and how that could put you at risk for prosecution. The implications of opting out of Medicare and how that process works. How to structure your agreements with your Medicare patients to ensure you're compliant with Medicare. Common buzzwords to avoid, and I see this a lot: 24/7 access, membership, in other words you need to avoid in your marketing for Medicare compliance, common HIPAA violations in concierge practices and how to avoid them, and why Jim thinks we might start seeing more prosecutions for HIPAA violations in the future. And also some scenarios where physicians could be putting themselves at risk by the way they have agreements structured with companies like nutraceuticals or testing companies, or even the way they bring in a new associate into the practice. So I think there's a lot to pay attention to here, and the interview with Jim was really good. We cover kind of a broad range of topics, and there were a lot of things we wanted to go into more depth with and just didn't have time. I think specifically data compliance, cybersecurity, and then even just some general business resources for physicians. So we talked after the interview briefly about putting those together in some sort of online module or online course, or videos, resources where you could come from your home or from your office and have access to them. So if that's something you'd be interested in, shoot me an email, taylor@conciergemedicineradio.com, and we'd be interested in talking some more with you about that. So without any further ado, let's get to the interview. Hey there, and welcome to today's episode of Concierge Medicine Radio. We're joined today by Jim Eischen. Jim is a partner at Higgs, Fletcher Mack Law Firm in San Diego, California. I've spoken with Jim a couple times now, and I wanted to bring him on the show to talk about some of the legal issues surrounding setting up a direct pay or concierge practice. I think because it's so new, there's a lot of variety in the different models, in different state laws, and it's important that new practices and existing practices have a sound legal structure. So, Jim, give us just a couple minutes of your background as it relates to direct primary care and concierge medicine. Where are you coming from?
Happy to do that, thanks. So I'm a California attorney. I've been practicing for 27 years. My practice has involved general business, corporate, real estate, and healthcare. But specifically for the last 5 or 6 years, I've been very actively working in the space of private patient reimbursement or compensation. So whether we're talking about medical groups or physicians who want to start a private pay practice, and by that I'm referring to what you could call concierge, or what you could call direct practice, or boutique or retainer, or if you're talking about software platforms or software providers that are selling some kind of solution that involves a patient contributing additional money and procuring some kind of a health product or health consultation. That's something that I've been working on very actively for several years and engage in that all over the country. I also am a regular speaker for the American Academy of Private Physicians, and I do the legal compliance talks for their conferences around the country. I've also done conferences for other educational providers, including WorldLink I recently spoke at a direct practice conference in Washington, D.C. I also recently spoke for a concierge healthcare conference in Orange County. And I regularly give these talks because I really believe in the need for our country to reform our reimbursement process for particularly primary care. And I really do believe that private medicine is a market solution that delivers an improved, reformed version of primary care.
Well, we were chatting before the call a little bit that this is just such a young industry, which from a legal standpoint, there's kind of always this drag that it takes a little bit for the law to catch up with kind of how the market is changing. So I know that creates some things that people doing private medicine need to be aware of. Do you want to start with just maybe a broad overview of particular points of interest, and then we can dive down into each of those?
Absolutely. So first to your first point, you're absolutely correct. Both state and federal governments are struggling to catch up with the amount of innovation that's happening in our country with respect to healthcare apps, healthcare devices, modes of communication, the fact that we more and more frequently are communicating electronically, and then also this reform that's happening in medicine where there's more and more interest in trying to figure out how do we reimburse physicians for a type of care that really makes sense. You know, it doesn't cause plans to go broke. It causes better healthcare outcomes. How do we get there? Federal and state governments, private and public plans, are very actively working on how to figure out the sweet spot for physician reimbursement. What do we do to deliver better coordinated care? Meanwhile, private medicine has arisen on its own and has really been slowly but steadily growing since the 90s. And yes, as you point out, the regulations have not really caught up to this innovation because, frankly, the regulators are really just trying to figure out how to reform plan reimbursement. And so there are no safe harbors or really clear guidance for private medicine right now, and that does create some compliance uncertainty.
Let's work from the perspective of I'm a concierge physician or I'm a direct pay physician. What's kind of the core things I want to be concerned about?
That's a great question. So first of all, if you are a private physician, and I'm using the word private, I could just as easily say concierge or direct, but private is generic. But the general compliance issues to deal with, we really start with Medicare. So for most primary care practices, and by the way, it doesn't have to be primary care, but it statistically often is primary care. The main question is, am I collecting a private fee for a service covered by Medicare? Now, even though the patient may be consensually wanting to pay an additional fee, and even if the physician is charging what you could argue is a, quote, reasonable fee for that event, let's say it's an office visit, a medically necessary one, if that patient is Medicare eligible, and if the physician is Medicare participatory, in other words, this physician hasn't opted out of Medicare formally, then federal law prohibits the physician from charging that patient more than what Medicare coverage reimburses. That's not permitted. That's illegal. So the fundamental challenge with private medicine is how do we structure the practice to ensure that the private fees paid by the patient are allocated to services not covered by Medicare? Alternatively, the physician may opt to officially opt out of Medicare, submit sworn papers confirming that they do not want to be Medicare participatory. Physicians can do that, and then for 2-year windows of time, they are 100% out of Medicare. When they exit Medicare that way, they are no longer subject to the Medicare assignment rules in terms of charging privately for covered services, with the exception of emergent or emergency care, because even an opted-out physician delivering emergency care is delivering care covered by Medicare. So when you ask what is the fundamental compliance challenge for private medicine, I would say this is it. How do you come up with a subscription revenue stream or a private pay stream that doesn't violate Medicare assignment?
So to make that a little more tangible, could you give us a fictional example or an anonymous example of how people get around that, or what the common ways are to structure a practice so that it's compliant?
Sure, I'm happy to. And again, I just need to make a very clear distinction between physicians who have opted out of Medicare formally versus physicians who have not opted out of Medicare formally. And just to spend a brief moment on that, many physicians are under the mistaken assumption that because they haven't billed Medicare for years, or they weren't aware that any of their billing went to Medicare, they sometimes will think that they have opted out of Medicare by just the passage of time or by not doing anything. And that's not a safe assumption. The only way to formally opt out of Medicare is to comply with Medicare's rules for opting out, to submit the sworn affidavit or papers indicating that you desire to opt out. You will not charge these patients for certain things, that the patients will receive written confirmation of your opt-out status, et cetera, et cetera. If you haven't done that, you have not opted out of Medicare. So anecdotal story number one, we focus on a physician who has not opted out of Medicare. This is a primary care physician who's very concerned that plan reimbursed primary care requires that they see too many patients a day in order to keep the doors open. So because plan reimbursement for primary care comes off of a menu, and the menu says that if you see a patient for so much time, maybe that's a level 1 evaluation and management, maybe the charge for that is $28.35 or something like that. That in order for that primary care physician to generate enough revenue to keep that office funded and open, maybe they have to see 30 of those patients a day. Well, the problem with that is that this is a physician who no longer feels like they know their patients as well as they want to. The patient population may be large. What is large? Well, it could be, say, 2,000 or 3,000 patients. That's too many people for them to really get to know well, especially if their visit time may be 6 or 8 or maybe 10 minutes. And so the problem is that there's a disconnect. Because of the nature of reimbursement for primary care, we don't have physicians and patients aligned into connecting more profoundly.
Let's work from that assumption then. So say we've already gone through this. They've come to this realization and they want to get into direct medicine. They want to spend more time with their patients. How do they structure their practice from a legal point of view to handle the issues you mentioned in terms of Medicare compliance?
So we always start from the question of what kind of medicine does the doctor want to deliver, not what's the compliant way to deliver medicine for better compensation. And the reason for that's obvious, right? In other words, we don't want to create practices that are just designed to make more money. The real problem for this hypothetical physician is they don't feel comfortable with the way they're doing primary care. So to answer your question, what they want to do is they want to generally reduce the patient panel. And then they want to create some form of subscription or revenue stream that allows a smaller number of patients to subscribe to the practice, whether it's monthly or annually. And so to do that, the patients are paying additional money. And so that additional money funds and makes up for the shortfall by no longer seeing 30 patients a day under traditional plan reimbursement, and then financially reimburses the physician for really delivering that direct care that I think we all think would do a better job of avoiding more plan utilization. So the question then becomes, how do you structure that practice so that the fees being paid by the patient pool doesn't violate Medicare? We always start from the assumption that the entire practice is Medicare eligible. Why? because it's really not good compliance to do a carve-out and say, well, we're going to have one practice for everyone under 65 or who doesn't qualify for Medicare, and then we have a totally different deal for Medicare eligibles. I find that to be compliance risky because it's easy to make a mistake. And when you really look at Office of Inspector General materials and you look at compliance guidance, I don't think that's a consistent approach with guidance recommendations. So we assume that practice is 100% Medicare eligible, and then we ask the question, what are the services this physician wants to deliver to those patients? And then what of those services are covered by Medicare versus what of those services are plainly not covered by Medicare? And then we allocate the private fees being paid by the patients to the non-covered services. And it's very important that this is not simply a superficial thing. In other words, it's not enough to just create a contract that says that and then do whatever you want, or functionally charge additional fees for covered services, because I believe that's risky and non-compliant. Rather, you really want to dig into each physician's own vision of healthcare and say, what do you want to do? What do you think is better medicine? And then you do your allocation of private fees for non-covered services versus Medicare billing for what Medicare covers, and then collect a copay and deductible.
So let me kind of create an example here, and you tell me how it works. So let's say there's a Dr. Wilson. He's doing primary care. He has retainer-based medicine. He's got a patient panel of, let's say, 600 patients. How would he structure the billing and everything so that he was compliant with Medicare? Could you give us just an example?
There's actually no one right answer in my book. Generally, what I see happen with our hypothetical, we could have exclusively integrative consults that are non-covered. They could be routine annual evaluations that relate to integrative versus Medicare-covered type medical services. And then there could be communication amenities that directly connect to those non-covered medical events. Again, that would be non-covered, and that could be how a Dr. Wilson creates their version of private medicine. But that may not be workable at all for another doctor who is entirely disinterested in integrative health or doesn't practice it and wants to deliver, and I don't mean to denigrate integrative when I say science-based, but just literally, wants to deliver science-based traditional primary care. So the challenge of private medicine is there really is no one way to make it compliant. You really have to dive into each practice's specific features and allocate the private fees to what that doctor wants to deliver and is not covered by Medicare.
Are there any common mistakes you see?
Oh, absolutely. So because concierge medicine focused on access, 24/7 availability, and extended office hours, you'll find persistently throughout the country, if you look at websites for private practice, you'll see 24/7 communication, expedited scheduling, added hours to the office visit. And honestly, that's probably in 90% of all practices that call themselves concierge or private or direct. The reality is that when you really look at what Medicare covers, there's aspects of that the OIG could argue is covered by Medicare. For example, Medicare considers certain communications, no matter what time of day, to be covered or bundled with what they cover. Medicare would say that if you see a patient for a longer period of time because it's medically necessary, that's covered by Medicare. And then finally, the Office of Inspector General, I think, has made it clear that they don't want Medicare eligibles to be subject to a quote-unquote access fee in order to see a Medicare participatory physician. So what I see as a very common mistake is that practices will rely on anecdotal information, look at other websites online, maybe talk to other people, and essentially continue to replicate some of the messaging that has arisen from concierge medicine that I don't think is entirely compliant. At least it's not sufficiently careful enough to make it clear that the private fees are only being charged for non-covered services. So that's a common mistake. A, relying on anecdotal information and thinking it's okay, or B, sort of replicating and pushing forward with this messaging without getting good, updated legal advice on how to create these practices.
Yeah, I remember I wrote down a list, and you had this in a presentation I saw you give. Access, 24/7 communications, electronic records access, membership, preventative care, care coordination. Those are all kind of Medicare billing buzzwords to be avoided, and they're also ones I see all the time on websites and marketing materials.
Exactly. And just to get to this, there have only been two known prosecutions of what we'll call private medicine in the last, call it, say, 12, 13, 14 years. And in both instances, this was reported through an OIG advisory. These are all public record. They're very easily found. You can find these on the OIG or HHS.gov websites. And you'll find that in the descriptions of these violations that really what happened was the physicians provided a very general sense of, routine annual exam, optimization of health, more access to the physician, communication amenities, et cetera, et cetera. And when the OIG stepped in those two instances, they didn't specifically say what exactly was or wasn't covered. They just indicated that some of those amenities were covered. And so the general message I give to physicians is that if you take the time and effort to take care to really truly allocate the private fees to non-covered services, it can be done compliantly and within those OIG advisories. I really think the major problem is a lack of care, simply not wanting to dig into the details or specifics and having a generalized sense of safety because you're essentially messaging what everyone seems to be messaging to. And so I think that creates a potentially false sense of safety. But why isn't there more prosecution? Really, I think the answer is this really is not a high priority for prosecution. When you take a look at the OIG's annual prosecution or regulatory interests, you don't see this listed. And I think there's really two reasons. One, the penetration of private medicine and primary care is still relatively low. Depending on the numbers you rely on, it's a small fraction of primary care in America. It's an exciting area because it seems to be delivering a reformed reimbursement model that is exactly what I think plans are searching for, but penetration is nonetheless still pretty modest. That's one issue. The other reason I don't think it's a high level of interest, regulatory speaking, with the federal government is because there just isn't a sense of a real wrong happening, if you don't mind me putting it that way. I mean, when someone puts a bunch of patient files in a driveway and exposes thousands of confidential patient data to the world, one gets a sense that that's a pretty big deal. And I think the federal government is more rightfully interested in cybersecurity or patient record compliance. And I think the government's also rightfully more interested in fraudulent Medicare billing, because that's really where we are losing terrible amounts of money. Private medicine is not costing the federal government money. If anything, it's saving the federal government money because these practices tend to reduce the level of plan utilization.
Just to sum up a couple points, and both for my clarity and for the listeners, my understanding is there are ways to get around this in the short term. If you have a practice right now or you're in the process of setting one up, I know Dr. Tom Lagrelius, who is on episode 9 of Concierge Medicine Radio, he says something on his site like, you can reach me on my cell phone anytime except when I'm under general anesthesia. So he doesn't say 24/7 access, but you read it and yeah, you get the point, right?
Of course.
So you can still effectively offer all these services. You just need to be careful about how they're phrased, that you're not you're not going to create compliance issues. Is that right?
Yes. In other words, you just need to take care. And I do want to make again this point that for the physicians who remain Medicare participatory, you must take great care to differentiate between what are covered and non-covered services.
And anyone that's opted out, basically the last 25 minutes of conversation doesn't apply to them. Is that right?
Pretty much. I mean,
okay.
But let me say this. For individual physicians, I can see it being a sensible decision, but I don't think it's the right decision for everyone, and I don't encourage it because I do think you can comply without opting out. But I also want to make another point, which is just because you've opted out doesn't mean you have freed yourself from federal and state regulation. That's not true. So let me just speak directly to that. For opted out physicians.
That was my next question. So once we've passed Medicare, what's next?
So Dr. Wilson decides to opt out of Medicare.
All right.
Let's make it concrete. Dr. Wilson has been advised on what is necessary to opt out, or rather to comply with Medicare in, let's say, his integrative practice, and he says, wow, that's just too complicated. I want to go with a very simple message. I just want patients to pay me a certain amount of money, and I'm there for them, period, full stop, that's it. So Dr. Wilson opts out of Medicare. So let's run through that. First of all, there are windows of time to opt out of Medicare. So you have to be very careful to make sure that if you have made this decision and you want to move quickly, that you opt out within the cycle. Otherwise, you'll have to wait a few months in order to do that. Number two, you have not avoided all federal regulation, far from it. So instead, you are obligated to enter into a written contract with all your patients. It's got to be Medicare opt-out compliant. You still have to be very careful not to charge private fees for emergency services. And I do see that mistake being made around the country where private practices will emphasize that they are A, opted out, and B, well, we're there for you even in an emergency. That gives me pause because emergency care is covered by Medicare, so you can't allocate the private fees to that. Secondly, that contract has to be compliant with the opt-out requirements, and if you fail in that regard, or if you fail to maintain your opt-out every 2 years, the negative consequences are fairly dramatic. I won't go through them all, but they're just terrible. So you don't.
My understanding is they automatically opt you back in.
That's right.
So even if you've opted out after 2 years, they opt you back in without telling you.
Or let's say you didn't maintain a written contract with all of your Medicare eligible patients and you were audited and discovered to have violated your Medicare opt-out requirement to have a written compliant agreement with each patient. They opt you back in there too. And then they force you to disgorge all your private fees, and then they force you to then bill Medicare, but then they charge you a penalty for having failed to comply with the law. So as you can see, it's fairly horrific if you don't opt out of Medicare and then comply with the rules. The other point I want to make with opt-out is even if you want to go with a very simple messaging of you pay me per month, I give you primary care, you have to really watch for state law. State law will prohibit these practices from essentially engaging in insurance practice. So if I promise you a benefit of unlimited primary care for a flat monthly fee, one can argue that I'm maybe violating my state's law by giving you an insurance product without adequate capitalization or adequate registration as an insurance company. And from a state perspective, the state looks at that and says, well, what if all 600 patients want care? Or what if all 600 patients want to terminate? Would you be able to give them pro rata refunds? So I do caution practices that even if you decide to opt out of Medicare, that could be the right decision for you. But just, don't sort of think that you've, broken the shackles of all law and can now freely practice with no concern with respect to law. There's just different laws, different requirements. Yes, opting out allows you to pursue this on a more simplified basis, but there are some things you still need to be careful about. You have to avoid violating state law with respect to promising unlimited medical services for a flat fee. And you do have to be careful about emergency services. And then finally, because all practices really, in 2014, have electronic protected health information, you still have HIPAA compliance that you need to engage in. And so that has its own set of requirements, and you don't avoid that by opting out of Medicare.
So I want to get Dr. Wilson into HIPAA compliance next.
Okay.
One thing I think, and I may be putting words in your mouth here, tell me if I'm wrong, I thought I heard you say this at the conference. One way to effectively give unlimited visits without giving unlimited visits is figure out the maximum number of times you might see someone in a month and just cover it up to that amount. So say you're never going to see someone more than 8 times in a month. You say unlimited visits up to 10 visits a month.
Well, but I want to be clear that it would be a little more detailed than that. In other words, it's got to be real. In other words, I don't want to create an artificial contractual boundary that in substance doesn't mean anything. So for a Dr. Wilson, you'd have to look at Dr. Wilson's patient panel and really come up with a reasonable estimate of capacity. How many patients could you see a day in order to practice medicine the way you wish, and what are reasonable constraints that should be put on the practice so that patients understand what the limitations are, right? In terms of, well, how often could I be seen by this doctor in a given month? And so I look at it also from a consumer side. Let's make sure the patient understands what they're getting when they sign up. So maybe for Dr. Wilson, that's a maximum of 8 visits a month. Maybe it's 3. I'm not sure. It depends on staffing capacity and patient panel. But yes, I do advocate for that. I do say create limitations. It's not only better compliance, but it's also better for the consumer too, because I want them to have a sense of what they're getting and what they can expect for their fees.
Let's dive into HIPAA then. What does Dr. Wilson need to know about HIPAA as a concierge or direct physician?
So let's just say our hypothetical Dr. Wilson is sitting in a conference and his mouth is aghast when he hears about HIPAA, but he then realizes, oh, wait a second, I'm 100% paper practice. I've completely avoided HIPAA. And I can't tell you how many times I've been at conferences and I will hear earnest practice managers or physicians ask the question, well, am I even covered by HIPAA? My patient records are in paper. And I think we all know that in the last 5 years, the last 10 years, the last 50 years, our migration to electronic data is moving at a geometric rate. Even practices who don't think they're electronic are probably electronic and they don't know it. For example, their photocopier is probably now scanning paper as it photocopies and saves it on a hard drive. The doctor may not know that. Or there may be email communications or even cell phone communications that are creating electronic protected health information. And so the first thing for Dr. Wilson to understand is that you can violate HIPAA with paper files. And some people don't understand that. For HIPAA to apply, it just means that your practice has any electronic protected health information. Doesn't have to mean that all your records are stored in the cloud. It just means you have some EPHI. And if you do, then you're regulated by HIPAA. It would always be safe to assume in 2014 that you're regulated by HIPAA. It's just safe. So then the next question is, well, then what does that look like? So if you're Dr. Wilson, first of all, you need to make sure that you have a notice of privacy practices that you can show that you've provided to your patients that helps patients understand their HIPAA-based privacy rights. You also need to make sure that you're not using a form from 2 or 3 or 4 years ago. HIPAA final rule came out last year and became effective in September of 2013. And what that did is it changed the nature of some HIPAA regulations. So long story short, in very short order, which is September of this year, you need to make sure, Dr. Wilson needs to make sure, that all of his HIPAA forms have been updated, including his notice of privacy practices, in order to comply with the final rule. It added some requirements. It clarified certain privacy practices. So forms dated prior to 2013 are not going to be final rule compliant. So he needs to let his patients know what his privacy practices are, and that sounds pretty commonsensical. Number two, from a documentation perspective, Dr. Wilson should have a written business associates agreement with any non-regular employees, independent contractors, consultants, billing, software companies, any outside vendor or contractor who receives EPHI from Dr. Wilson should sign a written business associate agreement with Dr. Wilson in which that vendor or contractor says, I understand that I'm regulated by HIPAA now too, and I will protect this information, basically.
So let's say Dr. Wilson brings in a marketing firm to help him with his marketing. Do they need to sign the business associate agreement?
If the marketing firm is exposed to EPHI, the answer is yes. If the marketing firm has no exposure to EPHI, the answer is not necessarily. So the business associate agreement is only required when that vendor or contractor is anticipated to receive EPHI. It would be safer to assume that they will, frankly. So, and the BAA has also been updated under the final rule. And again, the old forms need to be sunsetted by September of this year. So physicians should be looking to their HIPAA forms to make sure they've been updated to comply with the final rule. And then finally, from a documentation perspective, when Dr. Wilson looks at his HIPAA compliance, he also needs to make sure that he's done an internal risk assessment. And what that means is he has looked at his software platforms, his scheduling software, if he uses that, his email practices, his use of cell phones and tablets, how he stores and maintains and protects EPHI. And he needs to have an internally documented memo or workflow in which he describes where his EPHI is stored, how it's transmitted and protected, and the commercially reasonable efforts he's undertaking to protect that data. So, for example, Dr. Wilson has a physician's assistant who uses a laptop, and the laptop has access to this practice's EHR or EMR, which stores patient data in the cloud and requires a password to access that information. And the physician's assistant has a laptop, and the laptop has access to the cloud solution. Question: should that laptop have a password protect on it so that if the laptop was stolen, the data couldn't be accessed? Answer: heck yes. Question: should EPHI that's being copied from that EMR or EHR to a disk, should the disk be encrypted with a password protection on it? Answer: heck yes. And these are the kind of things that in a risk assessment memo, the practice can note and make reference to. Now, does the practice need to wrap the laptop with titanium steel loops and then have 3 locks on it and then attach it by shackle to the physician's assistant as they travel throughout the country so that there is no possible way the laptop could ever be stolen? Answer: no. The HIPAA security rule is not meant to be fixed or rigid. There's not one set of protocols for data. It's supposed to be scalable and manageable, and it's supposed to take into account your resources. So if you are, let's just pick a company out of the air, Target, a company like Target may be expected to invest some fairly significant monies in cybersecurity. If you are Dr. Wilson, a medical practice located in Scottsdale, Arizona, with 3 employees, then the federal government doesn't necessarily think you're going to invest the same amount of money into your electronic data, but you need to invest a commercially reasonable amount of effort and money into that. So do you have to encrypt it with the highest level of encryption known to the world? No. But should you at least base level encrypt it? Yes. If you're target, should you encrypt it at a higher level? Probably. Probably.
So it's kind of a benchmark. If, you're Dr. Wilson and you're listening to this, you would say, just make sure any source or any access to EMR or EHPI is going to be encrypted at some level at a minimum.
Yeah. And my point is that what we're talking about is the HIPAA security rule, which is the requirement that a physician or health group or medical group or any covered entity engages in some effort to evaluate their electronic and other patient records and come up with reasonable safeguards to protect the privacy of those records. That's it. So for Dr. Wilson, if someone knocked on Dr. Wilson's door and said, "Hi, I'm from the federal government, I'm here to help you," and in particular, I'd really like to do a very initial audit of your HIPAA compliance, what would Dr. Wilson want to be able to show? Dr. Wilson would want to be able to show that he has provided his notice of privacy practices to all of his patients. And if for some reason he wasn't able to get it to a patient, there's some explanation why. But there's some record of that effort. Dr. Wilson would want to show that he's got a written BAA in place with all of his outside vendors or contractors who have contact with his EPHI. And then finally, Dr. Wilson would want to pull out of a file a document marked risk assessment. He would like to be able to show the government that on a rather up-to-date basis, so as Dr. Wilson has used other software, other devices, other platforms, he has on an ongoing basis made an effort to document his effort to protect privacy. And at that point, I think Dr. Wilson would declare audit victory with respect to at least his documented level of HIPAA compliance.
So he breathes a deep sigh of relief at this point, and then all of a sudden he hears about the anti-kickback statute and Stark.
You're going to take me there. So before we leave the world of HIPAA, I just want to point out there's 3 rules I want to make sure the physicians keep aware of. The privacy rule is self-explanatory. It's the rule that you maintain the privacy of patient data. The security rule is the requirement to engage in reasonable efforts to protect that privacy. The accounting rule is something that many practices are surprised by. So the accounting rule is that when a patient pays privately for certain services, the patient has the right to have data from that event segregated within their records. So that, for example, if the patient paid privately for certain medical services that are not covered by plans, they have the right to request that that information from that treatment not be provided to plans who would otherwise have contact with that information. The accounting rule is something that often people look at me and their jaw drops a little bit because they didn't really think that that was necessary. And I also talk to EMR or EHR platforms, and I generally advise them to make sure that their system is set up to be able to comply with that rule, so that if their physician software subscribers ask, that the platform can segregate privately paid for medical information data from the other data.
And is there a common occurrence you've seen with that in say, a Dr. Wilson?
Well, Dr. Wilson may just be unaware of this. So Dr. Wilson has...
But it doesn't have a lot of implications in terms of something he needs to wake up and do tomorrow.
Exactly. It's complicated, and there sometimes aren't easy answers to what a particular doctor should do. For example, there are some physicians who have absolutely no contact with plans. Question, are they still subject to the accounting rule if there's no plan access? I think it would be the safe assumption if I was a EMR software platform or a medical practice, safe to assume that you should be able to do it. Even opted out practices will create super bills and have patients who seek out of network reimbursement from their insurance plans for some services. So I think it would be safe and prudent to assume the accounting rule applies to you.
Okay.
So you're going to now segue me to another aspect of compliance, Stark and referral.
Yes. So I know there are kind of some common issues that come up here. We'll continue on with our story of Dr. Wilson. What is he going to run into in terms of running and opening concierge direct pay practice when it comes to Stark and kickbacks?
Well, here's what I want to do. I'm going to lay out some scenarios, and what I'll do is I'll say that this should raise questions. I'm not going to say necessarily what the answers are because it's always case by case. But here's things that should cause Dr. Wilson to stop and think. So, for example, Dr. Wilson goes to a conference on private medicine and is very excited because he's run into a laboratory who's come up with a very creative way in which the laboratory can compensate Dr. Wilson for referring patients over to the labs for federal plan reimbursed laboratory results. And the lab wants to compensate Dr. Wilson for his referral by giving him some level of compensation. The lab says, Dr. Wilson, we've run this by our attorney, and our attorney tells us this is 100% compliant. So can Dr. Wilson take that assurance to the bank and feel confident that Dr. Wilson's additional compensation from laboratory revenue is safe from inquiry? Answer, no. Dr. Wilson should get that checked by his own attorney and have that very carefully checked to make sure that that's not a Stark violation or referral issue. Second scenario, Dr. Wilson is approached by a nutraceutical company who is very excited about a line of food products that appear to be absolutely superior to every other product on the planet in terms of achieving improved diet, perhaps achieving medically necessary weight loss, perhaps in achieving a better level of nutrition. And so this company wants to compensate the doctor for selling these products and for recommending them. And again, assures the physician this is 100% legal. You have nothing to be worried about. Our general counsel says that this is not referral or kickback. Again, when you get into the sale of products and you're referring your patients to products, and these products are making claims that one would hope are scientifically based and validated, nonetheless, the fact that you're compensated for recommending a specific product to your patients needs to make you pause and get good advice on how any sort of relationship like that can be properly structured. Number 3, Dr. Wilson is very excited to add a colleague who's new from med school and very excited about direct practice. And this new colleague doesn't have any patients. And so Dr. Wilson, thinking very commonsensically, is thinking, well, what I can do is I can refer or I can send patients to you because I'm at capacity. And what you can do is then give me a certain percentage of your monthly or annual fees for the patients that I'm sending to you. And that should be okay, right? Because I've opted out of Medicare. Again, pause. There should be something about that makes you think that that structure may not be appropriate. There's lots of ways to structure office sharing. There's lots of ways of structuring the sale of administrative services. There's lots of ways of creating contractual relationships that are compliant without getting yourself into a Stark or referral issue. But that's an event that should make you stop and get good advice.
Specifically, the nutraceutical example is interesting because I see that all the time.
Oh, it's real prevalent.
So is it the case that all of these people are potentially subjecting themselves to prosecution and the federal government just isn't prosecuting it? Or are there always ways in all 3 of these examples to properly structure it so that you're not going to be subject to prosecution?
Yeah, that's a really good question. And you get right to something that I don't mind repeating myself about, which is just because you see something happening anecdotally and that person has not been prosecuted, you cannot assume that it's okay. Many times in the practice of medicine, if you get good collegial advice, if you receive a medical information update from a reliable source, you can integrate that into your medical algorithm of how you practice medicine. And good doctors do this all the time. They receive updated research, they find out about new research results, and they immediately integrate that into the way they practice medicine so that they meet their standard of care. This is a good thing. The problem is when you move into the area of law, this can cause trouble, because the truth is that you can see all throughout different areas of healthcare business some fairly non-compliant practices. And they just simply may not be high on the level of regulatory oversight for state or federal government. Our governments are often underfunded. Our government staffs are often overwhelmed, and they need to do triage, and they need to decide what are the things that we need to pursue that are going to protect the most amount of people and can accomplish something within our budget. And so you see a lot of nutraceutical sales in healthcare practices, and I do too. Are they all compliant? Probably not. Some may be very much compliant, and I don't want to suggest that they're all non-compliant. I don't think that. I think there's some very well organized, well-structured programs out there that are 100% compliant. I also think there's some programs out there that are maybe not so much compliant. But I think as physicians, you can be led astray if you observe that and don't get your own advice on how you should put your practice together. And that's my recommendation. Don't rely on anecdotal observation of non-prosecution, and don't rely on assurances that someone else's lawyer has checked this out and it's all copacetic. It may not be.
So let's say you're Dr. Wilson and you're approached by a nutraceutical company. They have hands down the best product you've ever seen. It's going to create amazing results in all your patients, incredibly cost effective. At that point, what would you do to make sure you do your due diligence?
I would check with a well-regarded and recommended local healthcare attorney and ask to consult with that attorney, if you don't already have such an attorney, on the proposed business relationship. And I would not rely on that company's marketing or even legal materials, but I would get my own confidential attorney-client protected legal advice on whether that is a safe and sound model. And if they are advised such, then fantastic. You know, that's good. But always remember, legal advice is personal. The general advice you might get out there on the web or because a friend of yours was told something is not personal to you, and it may not be accurate. So that's what I would recommend doing.
Well, awesome, Jim. I think we covered a lot here. Is there anything you feel like we skipped over that you want to make sure Dr. Wilson or a concierge or direct pay physician should be aware of?
I think I do. So first of all, I want Dr. Wilson, since we've created this hypothetical person.
Might as well run with it, yeah.
Might as well run with it, right? So Dr. Wilson, let's face it, has a high IQ. Dr. Wilson is very smart, and Dr. Wilson is extremely competent. But I want Dr. Wilson to step back and realize that legal compliance and business practices are not often anecdotally accessible, even to the most intelligent mind, that there are nuances and issues that may not make common sense and may not be observable quickly. And so I want Dr. Wilson to get good outside advice in areas where Dr. Wilson could benefit. It could be with tax. It could be with a good CPA. It could be with a good business consultant on good or better business practices. It could be from a HIPAA consultant who's locally recommended on how to implement good HIPAA process. It could be with financial information. Even with respect to leasing, it may be useful for Dr. Wilson, as intelligent, as competent as Dr. Wilson is, to get good outside advice on a lease or a purchase transaction. And then finally, definitely with respect to private medicine compliance, Dr. Wilson should get good legal advice on how to structure that practice to make sure it's compliant. And it doesn't mean that Dr. Wilson isn't among the smartest, most well-educated, and sharpest people in this country. It just means that some of these issues really do require some specialization, and Dr. Wilson will benefit and will come out ahead cost-benefit by getting good advice.
It's interesting to hear you say that. I've seen that kind of a similar phenomenon in unrelated people, not necessarily with physicians, but I think especially with smart, ambitious people, which I think covers a large percentage of the physician population. There's a tendency to think you can do everything, and I suspect that's true, but that doesn't necessarily mean it's a good use of your time or energy.
That's another really excellent point. Physicians are so time-pressed. They have so many things that they have to handle, so many things they have to mentally juggle, that even a person of the highest level of thinking and thought capacity, if under enough duress or stress, can make a bad decision or can, do something that they would later regret. And I do think, again, it's so important to take your time, to get good advice and to follow good advice, because in the end, that pencils out positive. It really does work out much better for our Dr. Wilson and all other physicians in the end of the day.
No, it's certainly easier said than done, though. I always used to laugh at my dad, and he'd come back home, he'd go to make rounds at 5 a.m. He'd come back at 7 o'clock, and then he'd get in the garage and start trying to fix stuff. And it'd be like, come on, you know what I mean? Hire someone to do that. You just worked 14 hours. Go to bed.
Exactly. And I'll tell you something else, though. Let me go the other direction on this. On the other hand, I would tell physicians to stop being told how to practice medicine by non-physicians. And so, many times I'm approached and I'm asked for sort of a magic solution for private medicine. Just tell me how to do it. Give me a contract template and just let me do my thing. And I always advise physicians, wow, you've been very frustrated with plan reimbursement telling you how to practice medicine for all these years and then paying you less and less. Why do you want me to tell you how to practice medicine? How am I any better than a plan? I really would encourage physicians to not take things for granted in terms of healthcare and how to practice medicine, and to really focus on how to do it in a way that's got integrity for them. What do they think is better? What do they think would be way better? And then to explore how to do it. And really what people like me are for is to help implement their good ideas, not to tell them how to practice medicine. So on the one hand, I really want physicians to get good advice for areas outside of their typical knowledge sphere. But on the other hand, please don't let other people tell you how to practice good medicine. No one knows that better than they do. And so when it comes to private medicine modeling, when I do my thing and I help physicians put these practices together, we always start with, how do you want to practice medicine, not how do we achieve compliance. Compliance comes after we set up how to do good medicine.
Absolutely. There's a great book by Dan Pink. He also has a TED Talk by the same name called Drive. And he basically outlines that the three core things that make fulfilling work are purpose, mastery, and autonomy. Very much in line with what you're saying and very much my experience as well.
Yeah, and I really do encourage physicians that while they can certainly align with large business units, they can certainly join regional or national private medicine models if that's what they want to do. I'm also encouraging physicians to explore maintaining their own autonomy, having their own practice. I know that sounds counter-cyclical right now. There's such a higher percentage of physicians going toward employment. I'm concerned part of that's just out of fear and the desire for safety, feeling that an institutional affiliation is going to give them more protection. And, in some circumstances, it very may well do that. However, I don't want to see physicians become 100% employed by anyone. And I think we all want to protect entrepreneurship in healthcare, particularly with primary care, but it doesn't have to be just primary care. It's nice to see physicians innovate, employ, create jobs, do healthcare the way they think is in integrity with what they think is good medicine, and we certainly want to encourage that.
And at least from my perspective, it certainly seems like that's exactly what we're seeing with kind of the rise and the growing of private medicine. But I think we could wax on all day about this. What is the best way for someone to get in touch with you, Jim, if they want to learn more, they have some questions?
Well, thank you for asking. So I am with Higgs, Fletcher Mack, a law firm in San Diego. But because private medicine is largely a federal compliance issue, I do practice in that area all over the country. And my firm website is www.higgslaw.com, Higgs, Higgs. And if you find my bio under Jim Eischen, you'll find that I am posting all my PowerPoint slide presentations from around the country, also articles I've written on HIPAA compliance, cybersecurity, private medicine compliance, business compliance. And I encourage physicians to go to the website, download or print those articles and read them and just educate themselves on these issues. It's free. There's obviously no charge. And I think that's a good place to start. Just educate yourself on what these issues are and then go from there.
Well, awesome. We will we'll put up links to your website and all those resources on conciergemedicineradio.com. So if anyone wants to go there, they can find links to Jim and his law firm and the information and the resources he's mentioned in the interview.
Terrific.
So, Jim, thanks for joining us. We appreciate it.
Hey, it was a real pleasure, and I really believe in private medicine, so I really appreciate the opportunity to speak to you today about that.
Absolutely. Well, thanks again, and everyone else, we will see you next week. Hey guys, this is your host, Taylor Pearson. To give you a little background on the show, after seeing my dad and sister, both physicians, struggle to find a good resource for how to transition from their traditional practices, I launched Concierge Medicine Radio to create a resource to help physicians and healthcare professionals launch, run, and grow patient-centered direct pay or concierge practices. If you enjoy the show and want to help us spread the word to other physicians and healthcare professionals, it really helps us out if you'll leave a review on iTunes. I know the iTunes interface is a little clunky to say the least, so we put together a quick guide on how you can leave us a review at conciergemedicineradio.com/review, or you can go to conciergemedicineradio.com and click spread the word.
Thanks for joining us today at Concierge Medicine Radio. If you found today's show valuable, we'd love it if you spread the word by leaving us a review on iTunes or sharing it with your friends. To see notes on today's show, please visit us at conciergemedicineradio.com. While you're there, leave us your email to hear about all upcoming episodes.